All right, good morning, everyone. We're here for this session, the implications of AIPRA. Those of you that were here earlier got the introduction to AIPRA, and now we're looking at the implications of the Act. A couple of housekeeping tasks beforehand. This is a CLE class. We've got a sign-up sheet that you can get to at the end of the class if you want credit as attorneys. We have evaluation forms on the tables. If you don't have one, let me know and I'll grab you one. But they are very helpful for us when we're putting these on. And again, the lunch is on your own today. So without further ado, Professor Casey Ross.
Okay, so we're going to spend some time together today looking at, I don't know, I kind of feel like this is going to be me griping a lot, and I don't want it to be negative, but I want us to look at some of the problems that occur. Maybe they've always existed, and in those cases, they were problems before AIPRA. They continue to be problems now. But we'll also look at some kind of tough situations that are created as a result of Congress passing the American Indian Probate Reform Act. Again, the goals of AIPRA are really taking a look at those concerns. Oh, I'm sorry.
I'm sorry, Casey. I know. Go ahead. The one thing I forgot to say was if you have a question, please raise your hand and wait for me to get there with a microphone because we are recording these.
Thank you.
Thank you.
Okay, so the concerns that still exist after AIPRA has been passed, some of those tough situations are actually because of the way that Congress put the act together. And Congress had a lot of goals in mind when they passed AIPRA, right? And we talked about those in the last session. If you weren't here for the last session, they're really just trying to reduce fractionation because we've got this crisis of fractionation that's existed for a number of decades. But in passing the act, Congress didn't think about a few things, and the fact that they didn't address some of those things just continues to have the problems that we saw before. We're just going to talk through some of those problems. My goal is to talk about some of the things that I've encountered in my practice. I am the director of the American Indian Wills Clinic at Oklahoma City University School of Law, and we provide estate planning services for tribal members in the state of Oklahoma who own an interest in trust, 5 tribes restricted or Osage property. And I've been doing that for a number of years, actually, since I started practicing law. I've worked on American Indian wills. I've written over 1,000 in my career, and I want to talk just a little bit about some of the problems that I'm still seeing for clients. But my goal is to kind of talk through some of the things that I observe in my practice, maybe get some feedback from you all as to whether those are also hiccups for you in your practice or in your area serving tribal beneficiaries. And then I'd also like to open it up kind of towards the end to hear about problems or hiccups that you're experiencing that you think may be a result of not, addressing it in the act or something that the act has created. So I'd like to have some time for us to kind of share concerns about how these things are actually impacting beneficiaries. So we'll go ahead and get started. And I want to just briefly touch on kind of what we went over in our last session for those of you who weren't here. When Congress passed AIPRA, they were really trying to achieve the goal of reducing fractionation. And you'll recall that Congress had tried to do that a couple of times before AIPRA, right? They passed the Indian Land Consolidation Act. It was challenged. The United States Supreme Court struck it down as unconstitutional. Congress took a second swing and amended the Indian Land Consolidation Act. It again went to the Supreme Court of the United States, again was found to be unconstitutional. So Congress was very concerned about wanting to reduce fractionation, but wanting to do it in a way that would achieve their goal but still be a constitutional treatment of property interests for Americans. So when Congress actually passed AIPRA, which has not been struck down as unconstitutional as of this date, when Congress passed AIPRA, what they did is they, number one, set up a uniform probate code, because before AIPRA, trust property was being treated according to the state law in which the trust property was located. So if you're a beneficiary, I have a lot of clients. If you're a beneficiary, you own an interest in Oklahoma and an interest in Montana, your Oklahoma interest would go one way under Oklahoma law, your Montana interest would go another way under Montana law. It was just a mess because there was just no uniformity in the way the interests were being treated or the way they were being probated. So when Congress passed AIPRA, they made this uniform probate code that applies to all trust property. It applies to the majority of Indian country, right? It applies to the majority of Indian country as defined by the federal act. But I want to make it very clear there are exceptions in the act. There are exceptions that say, hey, AIPRA doesn't apply here. AIPRA doesn't apply here. Make sure you consult with the act to make sure that whatever tribe you're working with is actually subject to the provisions of AIPRA. For those of you from Oklahoma, the five tribes restricted property is not covered under AIPRA. It's not one of the land bases that AIPRA applies to. Also, Osage interests in particular are not covered under AIPRA. Additional exceptions are, in Alaska and some carved out kind of reservation-based communities throughout the United States. So again, just check to see if those exceptions keep you from, working under AIPRA. But for the majority of Indian country, for the majority of trust property, we're going to be looking at AIPRA under that Uniform Probate Code. In addition to the code, Congress set up a uniform probate procedure that would go through an administrative process within the Department of Interior. The language in the statute about the probate process is not super fleshed out, but I'll tell you the Department of Interior has promulgated regulations that answer just about every question that you could ask about how a probate works over on the Department of Interior side. So that was another touch point of AIPRA. I'll tell you also, whenever we look at kind of how Congress is achieving its goals of reducing fractionation, they created a different intestate succession schematic for less than 5% interest. So if you have a beneficiary who owns less than 5% of an interest, then what ends up happening is their property, if they pass away without a will, their property is going to be distributed differently than if it's a larger interest, a more than 5% interest. That's just another one of the touchstones of that act. And again, we talked about that this morning, but for those of you who weren't here, AIPRA also sets forth a presumption of joint tenancy to try to keep landowners consolidating instead of further fractionating. And if you have questions about that, we can come back to it in a little bit. So I want us to talk through just some of the concerns, right? Some of the concerns that I've encountered in my practice. Some of these, like I said, are a result of AIPRA. Some of them existed before AIPRA. AIPRA didn't fix it, so we're still seeing the concerns. The first one I want to talk about is the way that AIPRA treats those highly fractionated interests, right? We're talking about those less than 5% interests. When we look at AIPRA, right, we have a situation where Congress has determined that rather than having those highly fractionated interests descend to a person's children, for instance, right? Rather than having that interest descend to a number of children for that less than 5% rule, what Congress did was they said, if you've got a less than 5% interest, rather than it being split among your children, we're going to make sure that only the oldest eligible heir inherits that interest so that we, reduce further fractionation. Again, that's something Congress did to try to address land fractionation, but I got to tell you, the clients who come to the American Indian Wills Clinic at Oklahoma City University School of Law are coming to us because they don't want their property to go to their oldest eligible heir, right? They're coming to us because they do not like the way that Congress says their property is going to go if they don't write a will. So they come to us to write a will to get away from this. And I'll tell you, I think it's a huge problem from individual trust beneficiaries' perspectives because I have so many clients, right? I mean, I am never going to run out of clients. I've got a wait list. I mean, we can't service all the clients that we need to service because there are just so many folks who come to us and say, I know that if I don't write a will, my property is going to my oldest eligible heir, and I don't want that. I want to be able to say where my property goes, right? So it's definitely a concern. The only way to fix it, right, is to write a will. That's the only way a client can fix it, is to actually go through with the process of writing a will rather than relying on intestacy. So I highlight it as a problem because I see it in my practice that it's a continuing problem. Congress did their best, to try to address the fractionation issue, but I don't know if consultation with Indian trust beneficiaries might have yielded a different result, right? Maybe they would have come up with something else that was more palatable because a lot of people just don't like it and end up coming to us to write wills to avoid the intestate provisions of AIPRA. Any questions or thoughts about that? I have a question over here.
At least you moved closer this time.
What are some reasons that clients want to further fractionate a 1% interest?
That's always hard, right? And I do have that conversation with my clients. If they come to me and say, I have that less than 5% interest, and rather than it going to my oldest kid, I want it to go to all my kids, and I want them to each get their own interest in it, right? I have the conversation with the client. Well, hey, client, you know that's going to further fractionate what's already a very small interest. And I'm telling you, the majority of the time, my clients look at me and say, I know, and I don't care. I want it to go to my kids. So I have clients tell me things like, I want to be fair. I want to be fair to all my kids. I don't want them to think that one kid is more important to me than the others. I have clients tell me things like, my kids will fight. They will contest the will. They will throw a fit if I, give only one of them an interest in the property and not all of them the same interest. So, every client comes to you with their own individual family backstory and such. And those are probably the two I hear the most. Just, I want to be fair, or I don't want my kids to fight. One thing that I have done, I found some success doing. A lot of my clients own multiple interests, right? So I'll get their individual trust inventory and it lists out every single interest that they have. And what I can do with that inventory is I can actually talk to the client about, instead of giving each of these to all of your kids and splitting them, let's go down the list and maybe give one to one kid, and then the second one to a different kid, and then the third one to a third kid. I've had some success doing that on occasion, right? Where clients are like, that makes good sense. Of course, they want to make sure that the acres are, equivalent. They want to, talk about how much is produced on the property, if any, and if that's equivalent, and kind of trying to massage it that way to avoid fractionation for them. But at the end of the day, my duty is to my client. And I don't care if, I make Congress happy or not, right? Like, I want my client to get what they want. But it's definitely touchy because, you can see it just getting further fractionated, and it is definitely a problem. But if that's what the client wants and is fully informed and that's how they want to treat their property, then that's the way I write it up.
And then those without a will, has it ever been tested? Like the youngest saying, hey, I should get that, or like in court, I guess?
So I'm not aware of any of those appeals, which would be filed at the Interior Board of Indian Appeals, right? Those would be IBIA appeals, because they'd be appealing the Department of Interior's probate process. I'm not aware of any of those appeals. They may exist. I'm just not aware of them. I don't know that they'd be successful. You never know. Judges will do what they want to do. But I don't know that they'd be successful because it's very clear in the statute, and it's carried over into the regs very clearly that, this is how it's supposed to work. Any other questions on that one? How many lawyers do we have in the room? Would you raise your hand? Are you guys writing wills for American Indian Trust beneficiaries? If you are, raise your hand. Okay. It's just so interesting to see the number of my clients who are like, no way, I don't like that. That's why I'm coming to you to write a will. It's the majority of people who come in my office. They're coming there because of this. So it's interesting. Yes, ma'am.
Okay. What happens if the less than 5%, the man dies without a wife or kids, no parents, grandparents, but siblings?
If it's a less than 5% interest, it goes to the tribe.
Okay.
The interesting thing is, on the intestate succession schematic for a less than 5% interest, they don't look beyond children, grandchildren, and great-grandchildren, right? They don't. So if you die with no kids, no grandchildren, no great-grandchildren, the property interest is going to go to the tribe in those highly fractionated cases. So if the interest is less than 5%, no kids, no grandkids, no great-grandkids, it's going to the tribe. If you look at the more than 5% intestate succession schematic, they go back up the family tree if it's more than 5%. So if it's a more than 5% interest and you got no kids, grandkids, great-grandkids, they'll go back up the family tree to parents and siblings. So it's interesting because you've got to, number one, figure out which percentage are you dealing with. Is it a more than 5% or less than 5%? Because there's a different set of rules that apply. Any other questions? And my clients don't like it. My clients come to me and say, I don't like the way that this is going to work out. Okay. All right. Let's talk about another concern. Okay. AIPRA sets up a presumption of joint tenancy. Now let's talk about joint tenancy and tenancy in common just really quickly. When you own property, you can own property in one of two ways. You can either own it with other folks as tenants in common, where you and the other folks on the property own an equal undivided interest in the property, right? So let's say you own a piece of property with your two siblings. That's three individuals as tenants in common. Each of you owns a 1/3 undivided interest in the property. You can do anything with your 1/3 interest that you want. And when you pass away, your 1/3 interest is going to go according to your will or by intestate succession, right? That's tenancy in common. When we talk about joint tenancy is a property ownership type where individuals own property jointly. So when they own property jointly, what that means is whoever outlives the rest of them gets the whole piece of property, right? So when you're talking about joint tenancy, let's say you own a piece of property with your two siblings in joint tenancy, right? Each of the three of you are joint tenants. So when one passes away, his property doesn't descend to his kids under his will or by intestacy. The property goes to the other two who are still living. And then when the second one passes away, excuse me, when the second one passes away, whoever's still standing is the one who's going to own the 100% interest in the property. Okay, so we've got tenancy in common and we've got joint tenancy. AIPRA has a presumption of joint tenancy, which means if a client comes to me and writes a will and they say, I want to leave my property to my 3 kids, period, right? If they leave their property to their 3 kids, what is going to happen at probate is the Department of Interior is going to interpret that to mean that the client said, I leave my property to my 3 kids as joint tenants, right? The reason that's interesting is because it's totally the opposite of what it is under every other probate law in the United States. Under other probate codes, if you leave property to more than one person, the presumption is that you meant to leave it to them as tenants in common, right? It's a presumption of tenancy in common. AIPRA flips it and says it's a presumption of joint tenancy. So it's really interesting the way that this plays out because the presumption of joint tenancy stuff is really under the will provisions in AIPRA. But you're seeing it on the probate side, even on intestacy, where the department seems to have a very strong preference for joint tenancy status rather than tenancy in common status. So the department, whenever they're determining who's going to get what property, if it's multiple children who are beneficiaries of a decedent's estate, you're seeing them make those multiple beneficiaries joint tenants rather than tenants in common. So the only way to make 100% sure that it's not open for interpretation, the only way to make sure is to write a will, okay? Write a will and specify in the provision, I want my property to go to my 3 kids as tenants in common, period. Or I want my property to go to my 3 kids as joint tenants, period, right? So every single will that we draft in the American Indian Wills Clinic has to include either tenancy in common or joint tenancy language because I don't want there to be any question after my client passes away as to what my client wanted. And the only way to overcome this presumption of joint tenancy is to say it loud and clear, right? So I just make my students make sure that's in every single will that we draft because I want to, again, make sure that we're doing what the client wants. Any questions about that?
So you're saying the department is presuming joint tenancy, but then we're seeing fractionation. Like, I don't know if we see too much joint tenancy. Like, it's just more split it 3 ways.
Yeah.
So why do you think the department is presuming joint tenancy?
So they certainly are if the decedent writes a will and leaves their property to more than one person and doesn't specify otherwise. They're certainly doing that, right? I don't know on the intestacy side because I have seen it in Oklahoma. I have seen the Department of Interior actually probate even an interest that's more than 5% that has the N equal shares language in the statute. I've seen them take that and still apply joint tenancy to it. But I don't know that that's a uniform process across the United States. I don't know that it's a uniform process across Oklahoma. I think there's some confusion about how far the joint tenancy expectation goes. Is it only if a will's silent, or are we going to be sending things joint tenancy no matter what because the statute clearly has a preference for it?
Hello. Does the joint tenancy presumption apply to interests in land that existed when the bill was passed, or just interests that are acquired from that point forward?
So only from that point forward, and it would be through a probate process, right? So if an individual passes away, as of the date of death, if it's after the passage of AIPRA, it's going to go according to this presumption of joint tenancy. Prior to the passage of AIPRA, it would have gone as tenants in common. So it depends on when the interest is being probated, when the decedent passed away.
Okay, thank you.
Yep. Any other questions about that? Okay. So again, spoiler alert, I think a lot of my fixes are going to be write a will, okay, because it was for the last one and it is for this one. I mean, like, you just really have to write a will to make sure that the client gets what the client wants insofar as how the property is going to be distributed. So, and I wish there were other ways to do it, right? Like less difficult ways. I mean, it's very difficult to find access to a lawyer who is trained in writing American Indian wills. And you don't have to be a lawyer to draft these wills. You don't. You absolutely don't. But it's really important that whoever's doing it understands how all of this works, right? And that they have access to a licensed attorney, that they have access to be able to get someone to provide legal advice when it's appropriate. So it definitely is a problem, because when we say the fix is to write a will, that's easier said than done for a whole lot of people, right? To find access to someone who can actually do it, that's a whole nother story. Okay, this is one of my pet peeves here. This has nothing to do with AIPRA, okay? This has nothing to do with AIPRA. This is a different pet peeve altogether. I have a number of clients who come to me who would like to make sure that their trust property is managed in a way as to save it for their children, okay? I have individuals who would very much like to protect their trust property through a trust mechanism. And I don't mean trust like the federal government operating as trustee. I mean like what any other property owner in the United States is allowed to do, right? I'm talking about just a trust, right? A trust. So this is something under wills, trusts, and estates. You know, I teach that at the law school outside of the American Indian law context, just straight up wills, trusts, and estates, right? If I'm writing a will for any person in the world, I can put a testamentary trust inside of their will. And a testamentary trust is just a trust that's in your will. That's all it is, right? But I can actually create a trust inside of a will and put that person's property into the trust so that it can be managed and protected for the benefit of beneficiaries that that person might indicate. It's a very popular estate planning mechanism for individuals with minor kids, right? I have a will, I have a testamentary trust in my will, right? So when I pass away, if my kids are not 18 yet, all of my property goes into a trust, and I have a trustee who will manage that property for my kids and protect that property until they graduate college. And when they graduate college, they get their share of my property. But it's a testamentary trust. It's a mechanism that's very popular to protect assets and to provide for beneficiaries, right? So I have a lot of clients who would like to use a testamentary trust to put their Indian trust property in, right? I have a lot of clients who would like to do that. But I'm telling you, you can't. You can't do it. So I like to push back a little bit. I like to push back on this because I'm told you can't, right? I get told by the Office of Hearings and Appeals at a training or something, you know, very early on in my career, I hear this. You're not allowed to put Indian trust property in a trust. And I say, why not? I just want to know, why not? Why can't we do that? And I'm told because you can't have a trust in a trust. And I push back on that because people do it all the time, right? Like, especially wealthy people will have a number of trusts that talk to each other. They'll have umbrella trusts that govern a number of smaller trusts underneath them. It happens all the time. So I push back on that again, and I say, well, wait a minute, that's not the rule for everybody else. So how come we can't have a trust that would also, you know, take in trust property to manage for the benefit of a beneficiary? And what I was told was there's a statute that says you cannot put trust property in a trust. And I said, cool, can I have the statute? I just want to read it. So this is what I got. This is the statute. And y'all, I have read this 400 or 500 times, all right? I don't think it says what they think it says. I just don't. I don't understand how they get there from this. So I totally understand the idea that the federal government has supreme authority over trust property as the property owner and as trustee with a fiduciary duty to individual Indian beneficiaries. I get that, 100%, right? But there has to be some mechanism for a person to say, we recognize that the feds have this supreme trust authority, but we would still like some testamentary freedom to create trust protections so that our kids can benefit from property without it being exhausted until they're 18 or something, right? I just feel like there should be some mechanism to achieve that goal for a client. The one that really upset me the most, I had a client in Oklahoma. She was 32 years old. She had 3 children. And she had spent her life, like her entire lifetime, going around to family members and buying up family members' interests in property such that she had, it's unbelievable in Oklahoma, unbelievable. She had 100% interests in a number of parcels of property. I mean, she made it her life's mission to try to consolidate some stuff in her family. I thought it was amazing because she just did this when she was like 18. She had it figured out. She's like, I'm fixing this. So she did all this great work. She owned these 100% interest in property, and she's got 3 kids, right? So she comes to us, and I mean, I'll just tell you, her property was producing quite a bit of income. She had quite a bit of money in her IM account, and she had been diagnosed with cancer. So she wanted to set up a testamentary trust like we would do for any other person in the world, right? She wanted a testamentary trust that would take her trust property and her IM account and have some trustee oversight of a trustee that she nominated that she could have manage the property for her 3 kids, so that, you know, her 3 kids would not be subject to any kind of, you know, financial fraud or financial abuse. It was just like a good idea to have these extra protections set up. And I mean, she comes to us and that's what she wants. And I have to look her in the face and say, I can't do that for you. I could do it for any other person on the planet for any other type of property, but I cannot do it for trust property. I mean, it's just really, really upsetting, right? So we find other mechanisms to use. We work around it and stuff. But at the end of the day, it really drives me crazy that we just don't have that as an available mechanism for trust property, because I think it could be very helpful. There have been a number of clients who've come to me, and had they not had trust property, I'd have thrown their property in a trust and been on my way, right? But because of this alleged prohibition, I can't do that. It's one tool in my toolbox that's taken away for trust property, and it makes me crazy. Have any of you encountered anything like that? You understand why people would want to trust, right? Like, I mean, I don't want my kids would buy candy and silly string if they got that money immediately, you know? I have a question back here.
Hi, my name's Tanisha. So my question is there a fix? Because I can tell you personally, I'm in that situation right now. My mother's not in the best of health. She did write a will 10 years ago. And 10 years ago, my son was 6 years old, and she had left everything to him, and he's still a minor.
Yeah.
And when that time comes, which, you know, in the next couple years, it's going to happen, we're going to be in this situation.
Yeah.
And, is there a fix for that?
There's not. I mean, there's really not. There are things you can do to work around it, right? You can put Band-Aids or duct tape on stuff to just try to hope that it holds, right? I had a client who had one daughter, and the dad of the child was awful, right? Like a terrible person. He had left when the baby was born, had never had contact with the baby, ever, ever, ever. And we were working through concerns about where the baby would go when she passed away. She also was diagnosed with cancer, okay? So we're working through concerns about guardianship, right? Who's going to get the child whenever the mom passes away? And so we were able to put some language in the will to indicate why the child should not go with bio dad, right? Because there's a presumption under custody law that kid belongs to bio parents, and then other people come after them. So we're working through that. But really what mom was most concerned about, number one, she said, he's not going to want her. He doesn't want the responsibility of raising a kid. He doesn't want her. He said, but he'll want her long enough to drain all of her account. And then when he's done draining her account, he'll take her to my mom's house and drop her off, you know? So like, there is no way to fix that. I could do it for anyone else. I could write a trust and make it happen, right? I can't do it for these. So what we did in that instance was we talked with the Department of Interior, and we made a request that once her property passed to her child, that it be put in supervised status, which has some heightened review and approval requirements for withdrawals, right? So we asked for them to please just, you know, make sure that they're looking at every single request for withdrawal and not granting them, right? As a matter of policy, try not to grant a whole lot of them, right? But that doesn't make me sleep any better at night, because I understand that there are discrepancies in the way that those things are processed, right? I mean, there are some folks who process those applications, and if the thing's filled out and it all looks right, they approve it. And then there are some who sit and look at it and say, I don't think you need that much money for school clothes. I'm not distributing, right? So, yeah. I mean, I can do some things that I think are like duct tape or Band-Aids, but it's not a true fix. There is not a true fix for this. And it's just very frustrating, because it would be an available mechanism for anybody else. And it's just awful that it has this kind of discriminatory impact on Native people. It's crazy. So we will have a session after lunch about Family Trusts Project. The Indian Land Tenure Foundation is doing a whole lot of work. There's some language in the American Indian Probate Reform Act that is kind of a placeholder for the development of a project where families could come together and conglomerate interests and manage them together, kind of almost as mini trustees, right? There aren't any of those programs that are, fully developed, but there have been a lot of conversations and a lot of movement on that. So we certainly encourage you to come back and talk to us about that for the next session, which is going to be a roundtable where we kind of talk about that project and ideas for that project, because this is one component that we would hope to address with that mechanism, but it would have to be fleshed out, it would have to be authorized by the department, and it would have to kind of have the stamp of approval from a compliance perspective with AIPRA. So, there's a possible fix in the future is the best I can say, but there's just not right now. Any other thoughts or questions about that? Does it make you mad? See, I told you I was just going to stand up here and complain, and now I feel like I've made everyone mad. I'm sorry. But it's not I didn't write this. It's not me. Okay. All right. Let's talk about another concern that we see. I'm sure you guys are seeing this as well. When we talk about the way that probates work, on Indian trust assets, it depends on where you're at. It depends on the agency. But I've seen probates get done as quick as, 3 months, but then I've seen some drag on and on and on and on for years and years and years, right? So it kind of depends on how difficult the case is. It depends on how quickly a file can be put together. It depends on staffing. It depends on whether the federal government shut down or not, right? We definitely have a whole lot of hiccups that occur. And we experience this, right? We're in service to Native people. We experience this situation where they just can't get their probates done. It's like, come on, let's get it done. It's taken forever. So when you look at the Department of Interior regulations that flesh out the American Indian Probate Reform Act, it tells you just about everything you need to know about a probate, like what all has to be put in a probate file, all the different steps along the way of how the file's going to be reviewed and how it's going to be sent over for action. You have a pretty good playbook there for how it's going to go. But the problem is, even though you've got this probate file and you've got this procedure, it's just a very labor-intensive and paper-intensive environment. One little hiccup of not being able to find a death certificate can delay a probate indefinitely, right? So it's definitely something that we're seeing. Hey, Congress wanted to make sure there was a uniform probate process. We got that, right? But it's just not perfect, right? It's not perfect in that it's taking a whole lot of time and it's requiring a whole lot of staff time and a whole lot of paper development to get these probates through because the regulations are pretty onerous insofar as what they require to finish a probate. So I want to talk just briefly about the Department of Interior's their problems here, okay? And now this information is from my own personal experience a few years ago. Keep in mind, nothing I say reflects the ideas or opinions of the Indian Land Tenure Foundation or the Tribal Land Association. These are all just my opinions, okay? But I went to this meeting with the Department of Interior, okay, in Albuquerque, New Mexico. I go to this meeting, and we're talking about the probate process, and we're talking about how long it's taking, right? And the Department of Interior staff who were there were 100% on board with admitting we do not have enough staff to get this stuff done. We don't, right? And it just broke your heart. You feel bad because these people are like just working, and they can't clear the backlog of probates. They just don't have enough people. They don't have enough staff hours that are dedicated to this. And, you look at the Department of Interior and they say, well, they keep cutting our funding. What do you want from us? It's a bad situation. So a few years ago, when we were at that meeting, we heard from Department of Interior probate workers who told us they got about 4,000 probates in the door a year. They got about 4,000 in the door to process. And that at their staffing levels at that time, they could only complete 2,500 a year. So there's a backlog that rolls over to the next year and then rolls over to the next year, such that the backlog is so much, right, that it would take years of just working on the backlog to clear those, not to mention the new 4,000 that are coming in that year. Does that make sense? So it's just, a really difficult situation that the department finds itself in. So the average time, and this information is from a few years ago, it may have changed, it may have improved, it may have gotten worse, I don't know. But the completion time for a probate, the average was about 3 years. They were trying to hire additional staff. They were trying to train additional staff. They were really wanting to figure out ways to clear this backlog. And what we learned at that time was that the average cost of a formal probate, whether there was a will or not, it didn't matter if you had a will, it didn't change the cost of the probate. Isn't that interesting? The average cost of a formal probate was about $3,800 for a probate, for one. An expedited or abbreviated probate costs about $1,000, and that was based on their staffing time and their resources from the departmental budget that were dedicated to this probate process. So it's a high cost when you think about, 2,500 of those each costing either $3,800 or $1,000. It's a substantial cost. So, how do we fix the probate problem? How do we fix that? Okay, I have some ideas. So we have Congress appropriate a whole lot more money to the Department of Interior, and the Department of Interior gives a whole lot of more people jobs, and they get trained and they just come in and they clear the backlog, right? They just staff up and get a lot of federal funding, and they're able to just get these probates done. It's just a beautiful environment, okay? So that's idea number one. In the event that that won't happen, and I'm maybe a pessimist, but I don't know that that's going to happen, right? In the event that that won't happen, can we think of some other way to maybe clear off that probate backlog and expedite the processing of these files, right? Can we talk a little bit about what the outcomes are when these probates are left undone for so long? I mean, it really creates even more administrative burden when you're doing a probate 3 or 4 years after someone passed away, because you're trying to figure out how much money has come into the IM account, how much income has been produced since the person passed away until we finally got around to this file, because now we got to treat that differently than we would have treated income that came before the person passed away, right? It just creates additional administrative burden on top of administrative burden. It gets really out of control. So, I mean, we have a big interest in getting these done, not just because it's the right thing to do, but also because, we're just in the middle of an administrative nightmare. So let's talk about an idea we have, okay? Again, this is my idea. I think other people endorse it, but I will let them speak for themselves because, again, I don't want to get anyone in trouble. Transfer on death deeds, okay? Transfer on death deeds are mechanisms that are available for people who own property that's not Indian land, okay? I want to tell you what it is, and then I want to talk about how prevalent its use is outside of Indian country, okay? A transfer on death deed is literally just a beneficiary deed. And what you do, you own the property, you write a deed that says, when I die, I want my property to go to this person, right? You take that piece of paper, you go to the county where your land is situated, okay? This is not Indian land, by the way. You go to the county where the land is situated and you file it. They charge you $10 to file a transfer on death deed in Oklahoma. It costs $10, right? When you die, right? When you die, the person you named as the beneficiary takes a copy of your death certificate to the same county clerk, and they sign an affidavit that says, I am the person she put on the deed. Here's my driver's license. Here's her death certificate. And they transfer title from the decedent's name to the beneficiary's name at no cost. And you walk away and the transfer is completed, right? A transfer on death deed is this awesome mechanism where people can transfer property without having to file a probate, right? You don't have to file a probate. You don't have to deed the property over during your lifetime. You have the property your whole life, but the minute you pass away, that deed transfers title to the next person that you listed on your deed, right? If for some reason you file a transfer on death deed and then decide you don't want the property to go to that person, you can go revoke the deed. You just revoke it. You can execute a new one or you can just withdraw it. So it's just a really cool mechanism that allows you to transfer your property after your death without having to go through any kind of probate process, all right? It sounds awesome, right? It sounds really cool. The problem is you can't do it on Indian trust property. It's not an available mechanism for Indian land. So 27 states out of 50 allow transfer on death deeds. In addition to these 27, there are 6 with legislation on the books right now to pass to have them offered by November 1st, okay? So we're talking about this being a best practice. The states in the United States are adopting this as a best practice because it reduces all of the administrative and court nonsense that occurs every time you have to do a probate, right? So it's a best practice. It's a movement in this country that we're moving towards these transfer on death deeds with the recognition that probates take time and cost money and lawyers get rich off of them, and who wants to help them along, right? So when we talk about the jurisdictions that allow it, it's helpful to look at it on a map, because when you think about Indian country in the United States, there's a whole lot of Indian country included in those green states, right? So it's so frustrating. In Oklahoma, I can do a transfer on death deed for my client for their real property that's not in trust status. I can do it. I do them all the time. I do them for my clients because I don't have to probate their house, right? But on the trust property side, I have to tell them, yeah, you can't do that for your trust property. Sorry. You'll have to go through a probate. No matter what, you've got to go through a probate. You can write a will, and that clarifies your intent, but you still got to go through that probate, and it still could take 3, 4, 5, 6, 7 years, right? So it's really frustrating to have that mechanism for everyone else, right? Everyone else in Indian country, if you look at that, everybody else pretty much, right? Everyone else in Indian country has the ability to transfer their property at their death without a probate, except for those assets that are in Indian status. Any thoughts or questions about that? Just leave it with them.
Can you talk about the differences between transfer on death deeds and a will, and why would you do one or the other?
Yeah, sure. So a transfer on death deed is a beneficiary designation that takes effect the minute you pass away, right? You don't have to probate that at all. You don't have to. You just go sign a little certificate, show the death certificate, and they literally, the county clerk just changes title to your name, right? So it's like that. It costs $10 to file. That's it. If you write a will to dispose of your property, that's a fine way to do it too, right? But your will has to be probated. So you end up having to file a probate action in state court for your non-Indian trust property, right? So when we talk about writing a will to distribute your real property that's not in Indian status, fine way to do it, but it's just a heavier burden on your kids, on the people who are going to benefit, because instead of just being able to go up to a window and sign a piece of paper and show a death certificate, you've actually got to go hire a lawyer, you've got to file a probate petition, you've got to go to all the hearings and have a judge determine whether or you should or should not get the house that's listed in the will to go to you, right? So it just expedites the processing of the transfer of title, makes it a lot easier. It's way cheaper because you're not hiring a lawyer, you're not filing a petition, right? In Oklahoma, our filing fee for probates is right around $240. So if I can tell a client, you can either have your family pay $240 to go file a probate petition, or you can pay $10 now and you'll never have to do that. They always want the $10 option, right? So it's just, you can totally write a will. It's absolutely fine to do that, but there's a better way to do it, a cheaper way to do it that's quicker.
Do people choose a will over transfer on death when they have an option?
Typically, no. Typically, whenever I explain it to my clients, they're like, sign me up, do that deed, right? However, I still write wills, right? I mean, if I think I've disposed of all of my clients' stuff by other ways, right? Like I think I have beneficiaries on all their checking accounts. I think I have a transfer on death deed for all their real property interests. I already have someone else added to their car or their boat, right? Like I think I have it all done by will substitute. I still write a will because you never know, right? You never know if there's some property that person owned that you weren't thinking about. So it's helpful to have a will for every single client. But my goal is I want you to never have to use this will. I'm going to write it for you in case you need it. But my goal is for you to never need this because we're going to try to do all of your property outside of a will so that you never have to file a probate.
And then could tribes just do transfer on death deeds if they did their own probate code?
So we did have that conversation with the department folks, and their take on it was no. Do they have a reason? I don't remember one, but I think they want to see specific congressional language that authorizes the use of transfer on death deeds for Indian property. That's what they want to see. And short of that, I don't think they'll interpret it to exist any other way. But we did ask that question.
And because Casey had shared this with the foundation, this is one of the tools that we've been working on getting through Congress. Not much is going through Congress very quickly, but so as a follow-on, this is something that the foundation finds very valuable for Indian country, and we are looking at this as a legislative fix.
Another thing, when we met with the folks at the department, and I don't at all mean to say anything bad about these folks, because we were all in a room. It was like a round table just trying to work through these problems, and it's problems that everybody recognizes exists, right? It's not like we say it's a problem and they're like, no, it's fine. They're like, this is a problem. All these probates are crazy. But we had one of the folks from OST who was very excited about the possibility of having a beneficiary designation for IAM account, right? So like at the bank, right? I have a checking account. I can go to my bank and I can tell the bank, hey, when I die, I want this account to go to my kids. It's just called a payable on death account, right? So I go set up a POD on my checking account, and the minute I die, my kid takes a death certificate to the bank, and they give them the money, right? You can do that on checking account, savings account. You can do that on any financial instrument in the United States. You just can't. You can do a payable on death beneficiary. So that's an option for me to do, right? But if I have my IAM account, it's not an option for me. They don't have a payable on death option for those IAM accounts. And so we had a gentleman from OST who was in a leadership role who was really excited about the prospect of getting some congressional authorization to be able to do those beneficiary designations on the IAM accounts, because that in and of itself would save so much time and administrative burden if you could just, say who you want to get your IAM account when you pass away. Done deal, beneficiary designation. So again, it's one of those mechanisms that's available to everybody else except for trust property beneficiaries. And it's just so frustrating that we don't have all the tools in our tool chest to address these issues that we would have for, non-native interests. So if Congress ever introduces a bill for a transfer on death deed authorization for Indian country, I will be calling my congressman and asking them to vote in favor of it.
Is that another question about IM accounts and no trust interest? So how does that work when it's not greater than 25 or 5% or less than 5%? It's just an IM account. Like, is it still to the oldest child, or how do they? Who's an eligible heir, I guess?
Right. So on the less than 5%.
Well,
Oh, no. I'm sorry.
It's just the IM account
Yeah.
with money.
Just the IM account with money in it. It's going to go according to the intestate succession schematic for the more than 5% interest. It's on that more than 5% interest track. So it goes the same way. It'll be surviving spouse gets a third. Surviving children split the rest equally, right? And then if you don't have children, you go down to the grandchildren level, great-grandchildren. If you don't have that, then you go back up the family tree to parents and siblings. So it's treated the same as intestate is for all property besides the highly fractionated property.
Okay, thanks.
Yep. Any other questions? Okay, so a couple of things like for clients that we can do now to try to let them do some transfers during their lifetime instead of having to go through a probate. A couple of things we can do. We can have a client do a gift deed, right? Like a gift deed now, just to get the property to the person who they want the property to go to. Have a lot of clients who don't want to do just an outright gift deed. They'd rather do a gift deed and reserve themselves a life estate so that they can still continue with their property interest on the property throughout their lifetime. And then at the end of their lifetime, the gift deed would take control and the remainder would go to whoever they've nominated. So that's one option. It's not ideal because you can't revoke it, right? Like, what if the client changes her mind and says, never mind, I don't want my kid to get that property? Well, you've already deeded it over to him, so too bad, right? So the transfer on death deed is still superior because you can revoke those at any time during your lifetime and do a new one if you change your mind. So it's really, it's really something that I think would be beneficial, not just to Indian trust beneficiaries, but to the department, because it reduces that probate backlog and reduces the cost and the administrative burden of dealing with those. Same thing for those beneficiary designations on IM accounts. It would just solve so much. It would really, really help. Okay. I want to talk with you guys a little bit about other concerns or hiccups that you're seeing in your areas. Maybe a problem that existed before AIPRA was passed, maybe one that you've noticed now after AIPRA's been passed. Are you seeing other concerns? Are people coming to you with other concerns, or are you experiencing things that are annoying or problematic? Jim.
As a realty specialist for the Bad River Band of Chippewa in northern Wisconsin, one of the frustrating things prior to the passage of AIPRA were a number of non-Indian spouses under marital property statutes gaining access to the trust asset, or to the fractional interests, and those fractional interests going out of trust. So from my perspective, when I was a realty specialist, the passage of AIPRA helped to address that and keep land in Indian hands.
And that is something that we encounter quite a bit at the American Indian Wells Clinic, Oklahoma City University School of Law. We'll have a client who comes to us who is married to a non-native person. and the client says, I would like for my property to go to my spouse. And we tell them, if you leave your property to your non-native spouse, it will fall out of Indian status. It will no longer be considered Indian country. It's not trust property anymore. It just passes in fee to a non-Indian. And the vast majority of the time, I'd say 100% of the time, but 99% of the time, the client goes, oh, no, then I don't want to do that, right? I don't want to do a property transfer that's going to result in it losing its trust status. So AIPRA does authorize something kind of cool that helps out with that situation as well. AIPRA says if you want to, you can give a life estate to a non-Indian person. And as long as the remainder after that person's life is over, as long as the remainder vests in an Indian as defined in the Act, it can maintain its trust status from the time of the life estate beginning to it transferring over to the remainder status for an Indian beneficiary. So you can protect the Indian trust status and still let your surviving non-native spouse benefit from the property for her lifetime. So that's a good mechanism that we use a lot to make sure the land stays in trust status but still benefits the client's non-native spouse. Any other stuff you guys are encountering? Over here.
Hi, my name's Leslie. I'm from the Skokomish tribe in Washington. We have a lot of problems with fee interests on trust lands where we've just developed a forest management plan and we have an allotment, I think it's a 40-acre allotment, where 45% of it is in fee. So we can't do anything on that. How do we, and we've gone to our agency, our previous agency didn't have records. We moved over to the Puget Sound agency. They're trying to help us, but we can't even find, and we've gone to the county and a title company, we can't find a fee patent ever that took that out of trust. So how do we get control of that 45%? And the county wanted to foreclose on those fee properties, but we brought our superintendent in and stopped it.
Yep.
But it's still sitting there, and this is 4 years later,
It's-
at least.
It's miserable, right? It's miserable. Even if it's a majority fee, right, and a minority trust, you still can't get much done on it, right? We've encountered that in Oklahoma so much, and I don't have an answer to that. I don't know how to fix it, right? A lot of it is about coming together and trying to figure out ways to put the group together, to put the owners together to the largest extent and try to speak with one voice, right? But if you're talking about a minority ownership interest, it's not as effective, right? It is a continuing and ongoing problem, and it gets really crazy. We have leases on entire parcels of property, and the income on those leases goes to the Indian trust beneficiaries only. And the fee owners come in and say, where is our portion of that lease? And the department says, we don't owe you anything. We don't manage trust assets for anybody except our Indian beneficiaries, so you get nothing. But those fee owners say, wait a minute, you're doing everything you want on the property and we're not getting any compensation for it. Litigation, I see all kinds of problems with that. And I don't know that there's a good fix other than trying to maybe feed that as another potential mechanism to be developed by that family trust project, right?
Well, one of the other things that might solve it, or it might provide another solution in the tool chest, as Casey was referring to. What I share with landowners when I do presentations, and it's a lot less effective if there's high amount of income being produced on the property, because then even though they may not get anything, they may still see the dollars out there for the fee interests. But if it's undeveloped property, it may be much easier to find who those current owners are, because once it goes out of trust, the Bureau doesn't have any records. The county may also not have any records either, so you're kind of left to do your own probate work, as it were, to chase down who the current owners may be. And through that process, what I recommend is it's a lot of legwork, a lot of research on the individuals, but there may or may not be very much cost to getting those interests. By doing quitclaim deeds kind of all the way
Yeah.
through that chain. And with a quitclaim deed, you're clearing that once you have those assembled, like I said, it's a laborious process, but once you have those assembled, you file them with the county or township where those non-trust records would be, and take that paperwork to the Bureau of Indian Affairs and say, I am now the official owner. I'm already a trust owner in that parcel. I want you to take those under mandatory language and return them to trust status. Like I said, it's a lot of legwork, but it is a solution that you may be able to pursue.
And I mean, that presupposes that fee interest owners would even be willing to visit with you about, right, about deeding property back. And my experience in Oklahoma has been that they are not looking to play nice. They're looking to have the land taken out of trust status so that it's a usable fee parcel to them. You know what I mean? But hey, different parcels may have different circumstances, and you could approach that. I also wonder if it wouldn't be interesting maybe to talk to tribes who have compacted that realty function away from the feds to see if there is a different approach maybe that tribes have had some success with under a compacted operated program rather than a BIA operated program, because I think there's some more avenues for creativity under those compacted services than under the way that the BIA currently regulates things. So that might be another place to look, talk to your compacted tribes, you know, and just ask if there's a different approach. Maybe there is, maybe there isn't. There's right back here.
Hi, my name's Holly Sprague. I work at Muckleshoot. Just to your point on the fee owners, it's a problem there too, especially when we're going to do leasing. And so we've been working through this exact process that Jim mentioned, but doing it all in-house. And we've been so we're going back to the original probate of where the fee owner came in, locating them. At times we've had to hire private investigators for, you know, it's not too expensive, and then everyone has been willing to sell because they're non-Indian, they're not going to use the property. And we have the property appraised, we give them a fair market value, they're getting a random phone call and being offered funds, and they've all sold. So it has been successful doing this process and then cycling it back through the fee to trust process. So if you... So we pull the original probate where the fee interest became an owner, and we usually, if we don't already have a copy of it, we get it from OST, and they pull it from ProTrack. And so Anthony, or I guess Megan's not there anymore, but at the Everett office. And if you want, I can, yeah.
Any other thoughts or questions on that topic? It's good to see that it works some places, you know? I wonder if Oklahoma, they're just mean, you know? Maybe they just don't like to get along. I mean, what I think it probably is just the type of development that occurs on trust land in Oklahoma. I mean, people are very afraid of giving up interests that are mineral interests in Oklahoma. It's just people don't sell them. They don't give them away. It's like pulling teeth to get people to come to the table on those things. Okay, any other kind of hiccups or concerns or things that you think we ought to put in our brainstorming for trying to come up with some fixes? Okay, well, this is not the last opportunity you have. If you ever think of something, right, feel free to reach out to Jim. Feel free to reach out to me. If you encounter something, you want to brainstorm about it, or you just think, hey, this needs to be fixed, let's put it on the list of things to do. Really, we kind of keep this running list of technical amendments and recommendations that we would make so that anytime you get an audience with someone who could actually effectuate some change, you can have some things to talk about. So it's always good to, you know, keep those lines of communication open to try to gather some things. Okay, anything else for the presentation? Any questions, comments, thoughts, anything like that? Oh, we have one back here. Is that okay?
Good morning. I'm Patty Olby, and I'm with the Bureau of Indian Affairs, Superintendent at Minnesota Agency. And one of our tribes has been the first to exercise the purchase at probate option. I didn't attend your first session, so I don't know if you've talked about that. But just internal to the agency and everything working out that process and how do we do this, working with appraisals to make sure that we get the timely values, and just knowing where those funds are going to go to. You know, does the single heir, eldest child, where does it go?
So for purposes of monies, it's going to go either according to the person's will, right? Or according to the intestate succession schematic that is applicable to those more than 5% interest, right? So it's surviving spouse, kids, grandkids, great-grandkids. If you can't find anyone there, you're going back up the family tree to parents and then siblings. So it's going to be following that schematic. So are there things that you guys are seeing that are working really well as a result of that implementation? Are there things that look like they might need some more regulatory framework? I mean, what's your experience being the first there?
The experience has been a good one, actually, in partnering up with what used to be Office of Appraisal Services. I forget their name now, but we're getting values back in time. At first, we thought that was going to be the biggest challenge in meeting the judge's order for values within the 90-day time frame, but we've been getting them. So that was probably the first concern that we had. And then the form letter that actually goes out to the tribe that tells them, hey, this is subject to purchase at probate. It was so, it was written in a manner that it was legal speak, and I think they were just, tossed it aside until I met with them one-on-one and just kind of explained, hey, this means that you can purchase, because our area of Midwest is part of the land buyback program too. We're participating. And before that, we've participated in the Indian Land Consolidation Program, the pilot project.
Good. So
we have some tribes that have done that. So they were, some of them have money to purchase interests on their own, some of them don't. But some chose to participate, and I guess just knowing and explaining to them what this letter meant when they got it, because we send hundreds out, that they could do this, they started doing it. And then one of the things that we see now is the time that they have to actually pay for the interest. So we've just run into that problem with OST where they didn't submit their payment timely, and they didn't get the interest.
Oh, wow.
So that's important to be aware of too, is that you say, yeah, I want to purchase, but then follow through with the payment when the order comes through.
What's the turnaround time they want to see? Like how long do you have to process a payment?
I'm going to turn that over to my OST.
I mean, is it like
rep,
30 days? Is it 6 months? Is it?
Oh, yeah, I guess we don't know. I think it was 30 days
Yeah.
from the date that the order came through, is that they have
Yeah.
30 days to pay.
Which
So-
sounds like plenty of time, right? But I mean, I've tried to
Yeah.
get checks issued and it takes me 60 days sometimes. I mean, sometimes it's just a longer process.
Right. Well, and then the volume too of correspondence that BIA sends out, that the administrative law judges send out, I think it gets lost,
Yeah.
and just the volume, and to keep track of that one particular judge's order where
Yeah.
it's a final decision. I think that's an issue too. So some type of tracking mechanism
Yeah.
for these.
Okay. Thanks for that.
Yep.
Okay, we have one over here.
I've heard in some of the sidebar conversations here at the conference that Oklahoma is special, Osage is special, and that California is special. But I haven't heard any comments about how California is special, and I'm from California and just want to make sure I'm not missing anything, or direct it to someplace where we could look further.
Okay. There are definitely some additional resources that I think would be helpful, and the Indian Land Tenure Foundation has some on their website. Why don't we get together maybe after and just point you in the direction of a few things? I could talk to you about Oklahoma stuff all day long, but everyone would fall asleep and be mad because then they'd be late for lunch. So Oklahoma's wacky is all I can tell you, and California a little bit too.
So you can also check with CILS.
Oh, yeah, yeah.
It's closely related to this. In addition to the advancing transfer on death instruments, the Indian Land Tenure Foundation has found it would be very helpful to have a centralized storage and retrieval ability, and especially as an electronic storage and retrieval for wills. We've expended a lot of our own resources. We've also expended considerable federal resources to get wills written. But unfortunately, if the landowner doesn't make sure that it's accessible, if Bureau of Indian Affairs doesn't know that it exists, we've spent a lot of money that turns the probate into an intestate process anyway. And so again, I point out for you guys that if this is something that you find valuable, let the foundation know what resources would help that process. But again, if we could get the digital storage and retrieval available to Interior, I think that would make it much more effective.
You know, in Oklahoma, I think it's this way everywhere, but in Oklahoma, used to the BIA would house wills, right? So if you wrote a will, you could go put it on file with the BIA, and then at some point, they decided that they shouldn't be in that business, right? So they stop housing the wills. So they have the ones that they had before the new rule came out, and they still have them on site there, but they're not taking any more. So in Oklahoma, counties would let you file wills, right? You could file a will in the county where you resided. Okay, so that was an option. Then they stopped doing that because they were getting too many wills stuck in the archives, right? There are some tribal courts who still allow the filing of wills with the tribal court, which I think is really helpful because when someone passes away, you can call the tribal court and say, is that will on file? And the person who put the will on file is, of course, able to go withdraw it, revoke it anytime they want to. But it is a real problem having access. And to work on a will and to draft it and to get it beautiful and then to think that it may never see the probate process, like I have nightmares about that, you guys. Like I just want people to keep their wills like on them at all times because I just would hate to see them not followed. You know, you took all the time to do a will. You want it to be followed. You got to make sure it's accessible to people who can get it probated.
Okay, here's a problem I have with wills, and the OHA wants, to give them the original. Yeah, but then we also have probate, state court probates, which they want the original, and you don't. And so my clients are unwilling to give me their original
Sure.
will to send to
Sure.
OHA. So, do you know of a fix for that?
So the only thing that I have seen happen, and it's not a uniform process, and it's kind of every man for himself, right? Who knows how it works anywhere else? But I have had some success with taking an original in person, right? And asking them to make a copy that they could certify for their own records and then turn the original back to the client. I've seen that happen. It's not a uniform process. It depends on who's at the window, working the window at the time, right? I had a client, I'm going to tell this story, and I swear you guys can go to lunch. I had a client, we got a notice from the Office of Hearings and Appeals that a will we had drafted was going to be dealt with at a hearing, and that the will was going to be invalidated. The will was going to be invalidated. And I get the letter, and I'm like, I've never had one of my wills invalidated. What's up with this, right? So I get the letter, and the reason for the invalidation was the will that was produced was a copy, not the original, okay? So I call my client's wife, and I say, hey, did you have, in addition to it being a copy, they also said that it was not notarized, that the notary had signed it but had not stamped it, and without a stamp it was invalid. So those are my two reasons that they're going to invalidate my will. And I'm thinking, we've never not stamped a will. That's crazy. So I call my client's wife and I say, do you know where the will is, right? And she says, yeah, I know exactly where it is. And I say, well, they're telling me that they won't probate the will because it's invalid because it was a copy. So what I need you to do is I need you to find me the original so that we can get it probated. And she says, the original's at the agency. And I say, cool, so go get it. And she says, I tried to get it. They told me they wouldn't give me the original. They'd only give me a copy. And I said, okay, well, you need the original to do the probate, so we're going to have to make sure that we get it. But the interesting thing is it's all in the same building, right? This is all happening in the same building. So I asked her to please go get the actual physical copy of the original and call me back. This is what happened. On the notary stamp, you know, you have stamps that are ink stamps. Okay, but you know in the olden days how you had those embossing stamps that made like a really cool raised seal? Well, my notary had one of those embossing stamps. So when she stamped it, you can feel it on the original, but you can't feel it on a copy and you can't see it on a copy. So I finally get the original will out of the agency file that they'll let me take with me. And I can show the embossment that, you know, here's the original. And by the way, it is properly notarized. So my will's not going to be invalidated now, right? But I had to go through so much just to get that done. So I learned two things from that. Number one, the agency will sometimes tell you you cannot have a will. It's your will. It's in the files there. They'll tell you can't have one. I had people at one of the agencies in Oklahoma telling people, we won't give you your original will that we have in storage unless you bring us evidence that you've written another one. Like, I mean, just, that's not a threshold to revoke a will. That's unlawful. That's crazy. So, I mean, and that's, you know, training issue. That's a staff issue. I get it. So I learned, keep in mind the agency may hold your wills and you won't be able to get them. And I also learned if you have a person who uses an embossment, right when they emboss that, chalk the seal. Use a piece of chalk, right? Court clerks have a little piece of chalk in their top drawer. They pull it out and they chalk an embossment so that it'll show up on every copy that's made from now on. Always shade your embossment. Use a crayon, use a pen, use a highlighter, I don't care. But chalk that embossment to make sure that everyone can see that notary stamp, because they almost invalidated a will based on that. And it's just terrifying. It's just why we all spend so much time on this. Please don't invalidate our wills, right? So it got fixed, but whew, my blood pressure was high that day. Oh, got one more.
This is actually just a follow-up to what you were just discussing. Is there anything precluding an attorney from simply drafting two originals to avoid all that?
There's not. And I think that is something that you could do, right? The concern is wanting to make sure if a client wants to revoke their will, not having to go to two different places to revoke or destroy. Do you know what I mean? I would want to be very careful about the keeping of two copies, right? Figuring out where another copy belongs, because, you know, you give a copy to your kid who's going to be your executor, right? Or who's going to be a beneficiary of your will. If at some point you decide that you want to change your will, right, you shouldn't have to go round up copies from other people. I mean, it's problematic. I could see wanting to do it just so there's a backstop there, but you just got to be really thoughtful about all those, you know, revocation issues and, you know, freedom to revoke whenever you want to. You got to think about those things too. I also worry a little bit about giving anybody besides my client their will, particularly any of my client's children. I worry about elder abuse in a whole lot of instances where I'm afraid it's possible that a child will be angry that they were left out or not given everything or not given as much as, you know. So anytime I have an elder abuse trigger, I'm very concerned about letting anyone else see the will. I mean, they're just on a case-by-case basis that might work, but just be real thoughtful about how to protect all those different kinds of things. Any other thoughts? Okay, you guys have been troopers. Thank you so much for your time. Lunch is on your own, and the next sessions start at 1:30, so you've got some time to go grab some lunch. Please don't forget to fill out your evaluation forms on the table. They like the feedback, so if you could fill those out. And if you are looking for CLE credit, there is a CLE sign-in sheet up here on the front table.